So, picture this. You've farmed a piece of land for 20 years.
Okay, I'm picturing it.
You've paid every single tax bill, and the neighbors all call it your hill. But in the eyes of the Philippine legal system, you might effectively just be a squatter.
Yeah, that is a pretty harsh reality.
It is. Today, we're diving into a guide called originalregistration.pdf to find out how you actually turn a simple physical claim into a Torrens title.
Right, which is, a document so powerful it legally binds every person on Earth. It's essentially a form of legal alchemy.
Legal alchemy, I like that. We're moving from just possession to a state-guaranteed right.
Exactly. And the source material outlines two ways this kicks off. Usually it's ordinary proceedings, where you, the individual, take the initiative to file.
But sometimes the state forces the issue, right?
Yes, through cadastral proceedings. That's when the president orders a massive survey to settle every conflicting claim in an entire area all at once.
And once that process starts, it becomes an action in rem, which sounds like some really heavy jargon. What does that actually mean for someone just trying to secure their backyard?
Think of it this way. A normal lawsuit is just between you and one other person. An action in rem is the court telling the entire planet, this dirt belongs to this person, period.
Oh, wow. A judgment against the whole world.
Precisely. And because the stakes are that high, the entry requirements are incredibly steep. You have to meet the OCR standard.
OCR? That sounds like a military drill.
Close. It stands for open, continuous, exclusive, and notorious possession. And you have to maintain that for at least 20 years.
Wait, notorious? Do I have to be famous for living there?
Not exactly. In a legal sense, it just means your possession isn't a secret. You're living there out in the open, treating it like a true owner would.
Got it.
But even if you've been there for decades, there are hard ceilings. If you're a natural-born citizen, you can only grab up to 12 hectares of public land.
What about businesses?
Well, if you're a private corporation, the 1967 Constitution actually slams the door completely shut. Corporations cannot own public domain land at all. They can only lease it.
That's a massive hurdle for them. So, let's say I'm an individual and I meet the 20-year mark. How do I actually prove it? The text mentions something called muniments of title.
Those are your legal receipts, the deeds, the contracts, basically the paper trail that substantiates your claim.
And the source material gets pretty intense here with the Spanish grant rule.
It does. It basically says that in the eyes of the law, 1,000 years of ancestral history is often secondary to one piece of paper from a dead king or a formal grant from the Spanish crown.
That's wild. Without that paper trail, your claim is on shaky ground, which brings up the tax receipt trap.
Oh, yes.
I know so many people who think that because they have a drawer full of property tax receipts, the land is definitely theirs.
That is a very dangerous assumption. The law views tax declarations merely as indicia of possession.
Indicia of possession.
Right. It's evidence you might be there, but it is absolutely not a title. Without other proof, that shoebox of receipts is basically just expensive wallpaper.
So you've got your muniments, you've avoided the tax trap, and you file your application. Now you hit the triple notice, gatekeepers.
Yes, and the document makes it clear that if you miss one step here, the whole thing collapses.
It's publication, mailing, and posting, correct?
Exactly. You publish the notice in the official gazette in a newspaper, mail it to specific officials, and physically post it on the land. These are jurisdictional must-haves.
Meaning if you don't do them, the court can't even hear your case.
Literally doesn't have the authority. Even a small mistake, like trying to increase the land area in your application later, usually forces you to restart that entire expensive publication process from scratch.
It really is a gauntlet. But let's say you survive, you get your final decree of registration. Is that the moment you can finally sleep easy?
Almost. You enter a 1-year grace period. But once that year is up, we hit what I call the 1-year ticking clock.
What happens then?
Exactly 1 year after the entry of that decree, your Torrens title becomes incontrovertible. It is absolute. It wipes away all prior claims and protects you against the government and private parties alike.
It's such a rigorous system, but it's clearly designed to create total stability. You move from a maybe to a definitely that the law will defend forever.
Exactly. The system values certainty above almost everything else.
Which leads to a pretty haunting thought. Since the law makes a title incontrovertible after exactly 365 days to keep the system stable, what happens to the person who shows up with a perfectly valid, legitimate claim to that land on the 366th day?
That's a tough situation.
They might have the truth on their side, but do they still have a prayer? Something to mull over until next time.
So let's say you've got a piece of land. You've been paying taxes on it for years, and you know in your heart that it's yours. But how do you get that ultimate undeniable proof? The kind of proof that tells the entire world, hey, this is mine, no questions asked. Well, today, we're going to break down exactly how you get that. And this really gets to the heart of it, doesn't it? It's a question so many people have. You've got this whole stack of tax receipts, maybe a tax declaration with your name on it. That feels pretty solid. Surely that's enough, right? Well, the answer isn't quite what you might think, and it's the core of everything we're about to dive into. Instead of thinking about this as some dry, boring legal process, let's frame it a little differently. Let's think of it as a quest. We're on a journey to take a simple claim on a piece of land and transform it into something powerful, something permanent, an ironclad, government-backed certificate of title. So here's our roadmap for this quest. First, we'll tackle the problem of proof. Then, we'll look at starting the legal process. After that, a really big one, what counts as evidence? Then we'll walk through the gauntlet of the court. And finally, we get to the prize, the unshakable title. All right, let's jump right into section 1, the problem of proof. The goal here is huge. We're not just looking for a piece of paper, we're looking for a final decision that is binding on every single person on the planet. How in the world do you even do that? Well, it turns out there's a special legal process designed for exactly this purpose. It's called original land registration, and we're not just talking about filling out some forms here. This is a full-on court proceeding. Its entire purpose is to get a final official judgment on who owns a piece of land. And the power of that judgment is just immense. The legal term is that it's settled against the whole world. What that means in simple terms is once the court decides, it's done. It's final. Nobody can crawl out of the woodwork years later and challenge your ownership with some old claim. Okay, moving on to section 2, starting the legal process. So how does this whole quest even begin? It turns out there are 2 main paths you can take to get that official title. On one hand, you've got what's called an ordinary proceeding. This is probably what you're imagining. You, as an individual, decide to file an application for your piece of land. But on the other hand, there's a cadastral proceeding. This is totally different. This is when the government itself kicks off the process for a massive area, like an entire municipality, to survey and settle all the land claims at once. So either you start it or the government does. Now for section 3, and this is a big one. What counts as evidence? You've started the process, but now you have to actually prove your case. So what are the tools you need to bring with you on this quest? The absolute gold standard, the best possible evidence you can have, is what the law calls muniments of title. Fancy phrase, right? All it really means are the actual documents, the written evidence that directly prove your ownership. We're talking deeds, grants, official papers that trace the history of who owned the land. And this brings us right back to that question we started with. And here it is, straight from the Supreme Court. Tax declarations and tax receipts are not muniments of title. Boom. There you have it. That stack of receipts, as important as it feels, is not, on its own, the ultimate proof of ownership that the court is looking for. But hold on, that doesn't mean they're useless. Not at all. So what good are they? Well, the court sees them as a really strong sign that you possess the land as if you were the owner. The logic is just simple common sense. I mean, think about it. Who in their right mind would pay taxes year after year on a property they don't actually have? So while they aren't proof of title, they absolutely strengthen your claim. All right, on to section 4, the gauntlet of the court. Now, if you're going to make a decision that binds the entire world, you have to make sure the entire world knows it's happening. This is where the process gets really, really public. The court's power to even hear the case rests on these 3 pillars of notification. First, publication. A notice about the hearing gets published in the official gazette and a newspaper for all to see. Second, mailing. Notices are sent directly to people who might have an interest and to government agencies. And third, posting. A notice is physically tacked up on the land itself and on public bulletin boards. This whole system makes sure that anyone, anywhere, who thinks they have a claim gets a fair chance to show up and make their case. Now here's something that's so important to understand about how serious this is. Let's say you do all of this, and on the day of the hearing, crickets. Not a single person shows up to oppose you. So that's an automatic win, right? A slam dunk? Nope, absolutely not. The burden of proof is still 100% on you. You have to convince the court with your evidence that you are the absolute owner. Just because nobody objects doesn't mean you automatically get a title. And finally, we've arrived. Section 5, the unshakable title. You have walked the path, You've presented your evidence, you've gone through the gauntlet, and the court has ruled in your favor. So, what happens now? As soon as the court issues its final order, a 1-year clock starts ticking. Now, during this year, there's a small window where the decision could be reviewed, say if fraud was involved. But after that 1 year passes, that's it. It becomes absolute, incontrovertible. It is set in stone forever. That final court order is then officially written down into your certificate of title. And honestly, the best way to think of this document is like a birth certificate for your land. It officially proves its identity, its boundaries, and most importantly, its ownership for the entire world to see beyond any shadow of a doubt. And the power this one document holds is just incredible. It binds everyone, and I mean everyone, even the government. It's like a clean slate. It cuts off any old claims that weren't put on the title. You, the owner, hold that property free and clear of any hidden problems, except for the few specific things that are written right there on the document. Your property has now officially become registered land, with all the security that comes with that status. So at the end of the day, every piece of land has a story, right? A history of people who lived on it, worked it, and claimed it. But the ultimate question this entire process asks is this. Is the final undisputed chapter of your land's story written in an official, unshakable title? Because after this whole quest, that title, that's the final word. Thanks for joining us for this explainer.
I want you to close your eyes for just a second.
Okay.
And I want you to picture a piece of land.
Right.
But maybe it is not just any piece of land. You know, maybe it is that specific plot where your grandfather planted those mango trees back in the 70s.
Yeah, that classic family plot.
Exactly. Or maybe it is a spot in the province where you are planning to build your retirement home. You have got the fences up. You've got the neighbors coming over for coffee.
It sounds idyllic. I
Yeah.
mean, it sounds like the dream.
Yeah, the ultimate dream. You are the king of your castle. You have a stack of receipts where you have paid the property tax every single year since you were old enough to have a bank account.
You are invested.
Completely. In your gut and in the eyes of everyone you know, that land is yours. It belongs to you. But here is the nightmare scenario. And it is a nightmare that happens way more often than people realize.
It really is.
You wake up one morning, you get a notice, or maybe you try to sell that land, and the government, or worse, a complete stranger looks at you and says, "That is cute, but you do not own this."
That is a terrifying moment. The moment you realize there is a massive yawning canyon between possession, which is basically just physically sitting on the dirt, and actual title.
And that is exactly what we are unpacking today. Welcome to our Deep Dives. I am your host, and I am joined by our resident legal expert to get to the bottom of this.
Hi, everyone. It is great to be here to dig into this with you.
So our mission today is a deep dive into the absolute bedrock of property law. We're looking at original land registration, specifically Presidential Decree 1529. And I know I can hear you listeners clicking away already thinking a presidential decree sounds super dry.
Do not click away.
Yeah, stick with us, because this is literally the difference between leaving a legacy for your kids and leaving them a massive lawsuit.
It really is.
Yeah.
I mean, this is not just paperwork we're talking about. This is about establishing a right that binds the whole world. And I mean that literally. The law actually uses that specific phrase.
Against the whole world. It sounds so dramatic, like you were standing on a mountaintop with a sword challenging the entire planet to come and take your land.
In a legal sense, that is exactly what you were doing. When we talk about the Torrens system, which is the system of land registration we use, we are talking about a judicial proceeding.
Right.
It is a lawsuit.
Right.
You are suing to prove that you and only you have the right to this land against the state, against your neighbors, and against people you have never even met.
So our mission today is to decode this whole maze. We have a stack of source materials here. We are looking at comprehensive bar examination review pointers regarding land titles and deeds.
The real heavy-duty stuff.
The heavy-duty stuff, yeah. We are going to distill these sources and figure out how to bridge that gap from I am just farming here to I have a title that no one can touch.
And we will look at who can actually play this game, how corporations fit in or try to fit in, and why a tax receipt is definitely not a title.
Yes, we are going to bust that huge myth later on. So let us get right into part one, the arena. The source material talks about this process as a proceeding. As you said, it is not just filing a form at a desk. It is a literal fight.
It is a judicial fight. It happens before the regional trial court, and they are acting as a land registration court in this specific instance.
Okay, the regional trial court.
Right, and the goal here is to determine title and ownership. Once that judgment is final, it constitutes res judicata.
Okay, hold on right there. Res judicata. I have not heard that since a civics class I definitely slept through. Break that down for us non-lawyers.
Sure. It is Latin for a matter judged. It basically means we are done talking about this.
Like, is final.
Exactly. Once a court decides a matter with finality, you cannot bring it up again. You cannot sue again next year. You cannot have your cousin sue. The conversation is over. The truth is established in the eyes of the law.
So it is the legal equivalent of a mic drop.
That is a great way to put it. And in land registration, that mic drop applies to the entire world. It is what we call an in rem proceeding, meaning it is against the land itself, and it binds absolutely everyone.
Now, the notes mention there are two ways this fight can start. Two modes of attack. One involves you starting it, and one involves the government starting it. Let us talk about the first one, which is ordinary land registration.
This is your standard route. This is voluntary. So let us go back to your grandfather's mango farm. If he decides, okay, I am tired of worrying about squatters, I want my official paper title, he initiates the action.
So he takes the first step.
He does. He hires a lawyer. He files the application himself. He is the protagonist of this lawsuit.
He is picking the fight.
Yes, he is inviting the scrutiny. He is standing up and saying, I believe I own this, and I am willing to prove it in court.
Okay, that makes total sense. But then there's this other one, cadastral proceedings. It sounds like a medical procedure, like I need to go to the hospital and get a cadastral.
Does sound clinical, but cadastral refers to a public survey. This is the second mode, and the key difference here is that it is compulsory. It is not voluntary at all.
Wait, so I do not get a choice?
No, you do not. This is initiated by the government, specifically by the president.
The president is thinking about my little plot of land.
Well, not your specific plot, but the bigger picture of an entire area.
Yeah.
Imagine a town where nobody has titles. Everyone is just claiming this is mine, that is yours. Fences are mysteriously moving at night.
Fences always move at night.
Exactly. And nobody is paying taxes because nobody officially owns anything.
Yeah.
It's just total chaos.
So it is the Wild West.
Yes, the Wild West. So the president can direct a cadastral survey. They send surveyors to map the entire municipality. And then the government files a petition in court against everyone in that area.
Whoa. The government sues the whole town at once.
Essentially, yes. They file a petition to settle and adjudicate the titles to all that land. It basically forces everyone to come out of their houses and say, okay, I claim this lot, or I claim that lot.
And if you do not?
If you do not come forward, you lose your claim. It gets declared public land.
So ordinary registration is me raising my hand and saying, look at me, I own this. Cadastral is the teacher calling roll and forcing everyone in the room to answer.
That is a perfect analogy. The goal of cadastral is to settle titles on a massive scale. The government wants order. They need to know who owns what so they can tax it properly, and so there is peace in the community.
Okay, so whether I start it voluntarily or the government forces me into it, I end up in the exact same place, right? The regional trial court.
Correct.
And now I have to prove I should be the owner. This brings us to part 2, which is the contenders. Who is actually allowed to win this game? Because I am assuming not just anyone can walk in and claim land.
You assume correctly. This is where the rules get incredibly strict. The law is very specific about who can acquire alienable and disposable lands of the public domain. The primary contender is the individual applicant.
Just a regular person.
A regular person, but with a major absolute condition. You must be a natural-born Filipino citizen.
Natural born. So if I was born in another country, moved here, and became a naturalized citizen, I cannot do this original registration.
Generally speaking, no. This specific privilege of converting public land into private property is reserved strictly for natural-born citizens.
Wow. Okay.
Now, if you buy land that is already titled and private, that's a different story. But for original registration of public land, you need to be natural-born.
Got it. And is there a limit to how much I can grab? Like if I find a whole mountain without a title, can I just claim the mountain?
You definitely cannot claim the mountain.
Hmm?
The law sets a strict limit of 12 hectares. You can acquire up to 12 hectares by purchase grant or homestead.
12 hectares, that is roughly, what, 12 football fields?
Give or take, yeah. It is a substantial amount of land for one family. But why 12? It goes back to the philosophy of the Constitution. Social justice and agrarian reform.
Making sure there's enough to go around.
Exactly. We do not want a landed aristocracy where one single person owns the entire province. We want to distribute the land to as many families as possible.
Okay, so I am a natural-born citizen. I want my 12 hectares. What do I have to prove to the judge? The source, Alan, has this acronym, OCN. OCEN.
This is the golden rule of land registration. You must prove open, continuous, exclusive, and notorious possession.
Let us break these down because notorious is honestly my favorite word here. When I hear notorious, I think of a gangster or something. Does my possession need to be criminal?
No, absolutely not. In property law, notorious simply means known. It means you are not hiding your possession. You are not sneaking onto the land at midnight to plant a carrot and then running away before sunrise.
Right.
You are there in broad daylight. You are putting up a fence. You are building a house. You are acting as the true owner for the entire community to see.
So if the neighbors walk by, they point at the land and say, yeah, that is his spot.
Exactly. That is what notoriety means here. It is public knowledge.
What about exclusive?
Exclusive means you are not sharing the claim. You are not saying, well, it is mine, but it is also kind of the government's, and maybe my neighbor owns a little bit of it too.
No sharing allowed.
No sharing. You are asserting that you and you alone have the absolute right to this land to the exclusion of all other people.
And continuous. I assume that means what it sounds like.
It means uninterrupted. You did not live there for a year, leave for 10 years, and then come back and claim it. You have been there maintaining that claim the whole time.
And the big question here is, how long do I have to do this open, continuous, exclusive, and notorious possession?
The rule under PD 1929 is possession for at least 20 years immediately preceding the filing of the application.
20 years. That is an entire generation.
It is a massive commitment, and it has to be under what the law calls a bona fide claim of ownership.
What does bona fide mean in plain English for us?
It means in good faith. You honestly believe it is yours. If you are squatting on land that you know for a fact belongs to someone else, or you know it is a national park, you can stay there for 100 years and it will never count.
Because you knew it was not yours.
Right. You have to genuinely believe you are the owner and act accordingly.
So if I check all these boxes, I am a citizen, I claim 12 hectares or less, and I have 20 years of OSIN possession in good faith. What happens then?
The law does something almost magical. It creates a conclusive presumption. It conclusively presumes that you have performed all the necessary conditions for a government grant.
So I just get it.
The law basically says, okay, you have put in the work for 2 decades. We are going to treat this exactly as if the state officially gave you the land.
It essentially converts your sweat equity directly into a legal title.
Precisely. That is the core mechanism of original registration for individuals.
Now, this seems pretty straightforward for humans, but we have to talk about the elephant in the room from the sources. Corporations. Can big evil corp come in and register thousands of hectares of public land?
This is where the history of our constitutions gets really fascinating. If you look back at the 1935 Constitution, it was a bit more lenient. But under the 1973 and the 1987 Constitutions, the one we have right now, the rule is hard and fast. Private corporations cannot acquire alienable lands of the public domain.
Just a hard stop, no exceptions.
Hard stop. They are absolutely banned from ownership. Now they can lease land. They can lease up to 1,000 hectares for 25 years and renew it for another 25. But they cannot own it outright.
Why is that? Is this, again, about preventing monopolies?
Yes. Corporations have one massive, distinct advantage over human beings. They do not die.
That is a very good point.
A human can only hold land for a lifetime. But a corporate entity could potentially hold it for 500 years. If we let corporations buy up all the public land, we would essentially be creating a modern feudal system where corporate entities own everything and regular citizens are just their tenants.
Right.
The Constitution specifically wants to prevent that.
But I feel like there is a big but coming here, because you look around and you see big companies owning huge tracts of land all the time.
There is a massive but, and it comes from a very famous Supreme Court case. Director of Lands versus Acme Plywood and Veneer Company. This is universally known as the Acme Doctrine.
I love that it is called Acme. It really does feel like they pulled a fast one on the Roadrunner here. What exactly did Acme do?
So Acme Plywood wanted to register a large tract of land. The government immediately stepped in and said, no way, you are a corporation. The Constitution explicitly says you cannot hold public land.
Seems like an open and shut case.
It would be, except for the specific timeline of events. Acme did not try to buy the land directly from the government. They bought it from private individuals, farmers. And those farmers had already possessed the land for the required number of years.
Ah, so the farmers had already done the 20 years of OSIN work.
Correct. The farmers had what the law calls imperfect titles. They had not gone to court to get the actual paper, but they had met all the physical requirements. They had a vested right to the title.
So Acme buys the land from the farmers, and then Acme is the one who goes to court to register it.
Yes. and the Supreme Court ruled in favor of Acme.
Wait, how did that work? If corporations are banned from acquiring public land, how did they win?
The court used a very specific and brilliant legal logic. They said the moment those farmers completed the required possession, the land legally changed character. It ceased to be public land, and it became private property by operation of law.
So transformed.
Yes. It transformed before Acme even bought it. So when Acme signed the deed of sale, they were not buying public land, which is banned. They were buying private land, which is perfectly allowed.
That is incredibly clever lawyering.
It is the magic wand theory. The farmer's long possession waved a magic wand and turned the land private. The corporation just bought the result of that magic.
So this is the ultimate loophole. If a corporation wants land, they do not go to the government. They just find a guy who has been there for 20 years, buy it from him, and then register it themselves.
It's the primary method they use, yes. But there is a catch to this loophole, and this is where another case comes in, the T Properties case.
T Properties sounds like the direct sequel to Acme.
In the T Properties case, a corporation tried to do the exact same Acme maneuver. They applied for original registration of 56 hectares of land.
56 hectares. That is huge.
Very huge. And they said, we bought this from a private individual who had possessed it for the required time, so it's private land. But here's the problem. Do you remember the limit for an individual applicant?
The limit was 12 hectares.
Exactly. The individual they bought it from could only legally claim 12 hectares for himself. So the Supreme Court said you cannot acquire a right higher than what your predecessor had.
Oh, I see. If the farmer only legally owns 12 hectares, he cannot possibly sell you 56.
Exactly. The legal maxim is the stream cannot rise higher than its source. If the farmer was capped at 12, the corporation is capped at 12.
So the corporation can use the Acme loophole, but they're still strictly bound by the limitations of the human they bought it from. They cannot use it to grab massive estates all at once.
Precisely. It prevents corporations from aggregating massive tracts of public land by just finding one guy who claims he magically owns the whole province and buying him out.
Okay, that makes a lot of sense. It is a loophole, but it is a tightly controlled one. So now we know the players in the arena, we have the citizens, and we have the crafty corporations. Let us move to part 3 and talk about the weapons. When you actually walk into that courtroom, what do you bring with you? The outline calls them muniments of title.
It is a great old legal word, is not it? Muniments. It sounds almost like munitions. And in a way, they really are. They are your legal ammunition for the fight.
Your legal bullets.
Yes, muniments are the written instruments, the deeds, the wills, the old contracts, the survey plans that you hold to prove your title. They are the paper trail of your ownership.
But the sources make it clear that not all paper is created equal. There is a case here that I found really interesting to read. Gutierrez Hermanos versus Court of Appeals.
Yes, this is a classic case regarding the concept of native title.
The applicant here was claiming something truly massive. They said, we do not just own this because we have been here 30 years. We own this because our ancestors were here before the Spaniards even arrived.
Right. They were invoking a concept similar to what indigenous peoples like the Igorots or Kankanae tribes might claim. Possession since time immemorial.
Since before memory, that is such a powerful historical claim to make.
It is very powerful. But the court's view is that if you make a claim that big, you need evidence that is equally big. The problem in the Gutierrez Hermanos case was that they tried to prove this ancient native ownership using tax declarations.
Well, just tax receipts.
Just tax declarations.
Yeah.
And the court looked at that and said, no, that is not enough. Tax declarations are not muniments of title. If you are going to claim that you have a native title or a title that dates back to the Spanish era, you effectively need a grant specifically bestowed by the Spanish crown.
So you literally need a letter from the King of Spain.
Essentially, yes. You need a royal decree or a proper Spanish title document. You cannot just show up with a tax receipt from 1950 and say, this proves my family owned it in 1650.
This brings us to, honestly, the most relatable part of this entire deep dive, the tax declaration. I have to stop you here because I know for an absolute fact that if I go to my grandmother's house right now, she has a plastic envelope filled with these blue and yellow papers. And if I told her, Lola, these are not titles, she might actually hit me with a slipper.
She definitely would. And she would not be the only one. It is a massive cultural phenomenon. People treat the tax declaration like the holy grail of property. The mindset is, I pay tax, therefore I own.
Is it true at all?
Legally speaking, no. A tax declaration or a tax receipt is not a title. It is not conclusive evidence of ownership.
So are they completely useless? Should I tell my grandma to just throw them in the trash?
No, do not do that. They are definitely not useless. They are what the law calls indicia of possession.
Indicia, like indicators or evidence?
Strong evidence.
Yeah.
The Supreme Court has this line of logic that I absolutely love. They essentially said no one in his right mind would be paying taxes for a property that is not in his actual, or at least constructive, possession.
It is a purely psychological argument. Why would I voluntarily give the government money every year if I did not truly believe I owned it?
Exactly. Paying taxes proves you believe you are the owner and you are acting like one. It proves your good faith. It strengthens your bona fide claim. But, and this is the crucial key, it proves possession, not title.
Can you explain the difference between the two again, just to be totally clear?
Possession is a physical fact. I am here. Title is a legal right. I should be here. You can easily pay taxes on land you do not actually own. I can walk down to the assessor's office tomorrow and pay the property tax on your front garden. That does not magically make your garden mine.
That is a terrifying thought. So I could be paying taxes for 20 years diligently, but if someone else has the real paper title, I am basically just a generous donor to the local government.
Essentially, yes.
Mm.
The tax receipt is a weapon, but it is a shield, not a sword.
Mm-hmm.
You need it to prove you have been there to satisfy the OTIN requirement, but it does not replace the decree of registration itself.
Okay, so lesson learned for everyone listening. Keep the receipts, keep paying the taxes, but do not stop there. Go and get the actual title.
Exactly. Do not rely on just the tax deck.
Now let us move to part 4, the gauntlet. We have got our applicant, they have got their evidence, their 20 years, their tax declarations. Now they file the case in court, and immediately they hit this massive wall of bureaucracy called publication.
This is where so many cases go to die. It seems like such a simple procedural step, but it is highly strictly jurisdictional.
Jurisdictional, meaning if you screw this one little thing up, the court literally is not allowed to hear your case.
Correct. The court has zero power to act. The law requires the notice of the initial hearing to be published. This is the shout to the world.
Published where exactly? On a billboard outside the land.
In 2 specific places.
Okay.
First, in a newspaper of general circulation, that is for the general public to hopefully see. But the second one is the absolute killer, the official gazette.
The official gazette. Does anyone actually read the official gazette?
Maybe 3 librarians and a very bored law student somewhere. Nope, practically nobody reads it in their daily life. But legally, it is the Bible. Publication in the official gazette is what confers jurisdiction. It is considered constructive notice to the whole world.
So it is almost like a magic spell. Once it is printed in that specific government booklet, the law just assumes every single human being on Earth knows about your specific court case.
That is exactly how it functions. And if you miss the publication in the Gazette, or if the publication is late, your entire case is void. You have to start the whole process over. And on top of publication, you also have mailing and posting requirements.
Paperwork.
Yes. You have to mail the notice to specific officials like the Secretary of Public Highways, Agrarian Reform, the governor within 7 days of publication.
Yeah.
And you have to physically post the notice on the land itself and on the municipal bulletin board at least 14 days before the hearing.
Wow. They really want to make sure everyone has a chance to see this. And the notes mention something about amending the application, which sounds like a total trap to me.
It is a huge trap. Let us look at scenario A. Let us say you apply for your 12 hectares, you do all the publication, then halfway through you realize, oh wait, I forgot the mango grove next door. It is another 500 square meters. I want to amend my application to include it.
Makes total sense. Just staple a new page on.
You cannot just staple it on. The rule is if you add area, if you increase the land in any way, you must republish. New publication is absolutely mandatory.
Start the whole publication process from scratch?
Yes, because the court never had jurisdiction over that new 500 square meters. The initial shout to the world did not include the mango grove. So the world has not been properly warned about that specific piece of land.
Fair enough. But what if it is the other way around? Scenario B, what if I realize I claim too much and I just want to remove a slice? Or what if the surveyor made a tiny little error?
This is where we get the somewhat comedic case of Benin versus Tucson.
I saw this in the notes. They were literally fighting over what, 27 square meter?
27.10 square meters to be exact.
That is the size of a parking spot. And this was inside a huge estate, right?
Yes, over a vast tract of land. The burning legal issue was, did they need to republish the notice to the whole world because of this tiny, tiny discrepancy in the numbers?
And the court said?
The court brought some common sense. They said, do not be ridiculous. The difference was completely unsubstantial. It did not alter the core identity of the land.
property law is petty, but not that petty.
Exactly. The logic is, if you exclude land, you're not hurting anyone else's potential claim. You are stepping back. So usually no new publication is needed for exclusions or for very slight minor corrections that do not change the property's identity. But if you add even a little bit of land, you're stepping on potential toes, so you must shout again.
Okay, so the notice is perfectly published. The world has been charged with knowledge. Now we enter part 5 of the deep dive, the opposition. The enemies gather at the gate to fight back. Who usually shows up to fight you on this?
Well, obviously, private neighbors might show up. Hey, that fence is 2 feet on my side. But the opponent you could really be afraid of is the government.
The government again. I thought the whole point was that they wanted us to have titles to settle things.
They do want order, but they also have a supreme constitutional duty to protect the public domain. Remember the Regalian doctrine. All land belongs to the state unless it is clearly proven otherwise. So the Solicitor General or the Director of Lands will very often oppose your application just to make sure you are not accidentally or intentionally stealing a river or a public road or a protected forest.
They are the ultimate gatekeepers.
Yes, and they play by slightly different rules in court. There was a case outlined here, Republic versus ASOC. It deals with a late opposition.
Usually in a normal court case, if you miss a strict deadline, you are in default. You lose your right to speak.
Right. But in this case, the government filed their opposition after the general default order was already issued. And the court looked at it and said, we will allow it. They can still present evidence.
That seems incredibly unfair to the applicant. If I am late, I lose instantly. If the government is late, they get a free pass.
It definitely feels unfair on a personal level, but the overarching logic is public interest. The government is rarely barred by default in these land cases. Think about it. If a government lawyer is lazy or just misses a deadline, should the entire state lose a national park forever? Should the public lose a highway because of one lawyer's mistake?
Oh, I see. The stakes are too high for a technicality.
Exactly. The court says no. The state seeks to protect the public domain, so they get leeway as long as a final decision has not been rendered yet.
Now the outline mentions the basis for opposition. I cannot just show up to court and oppose my neighbor because I do not like him, right?
No, you cannot oppose just for fun or out of spite. Your opposition must be based on a real right of dominion or a recognized real right over the property. You have to have a legal dog in the fight.
Now, here's a scenario that I find really fascinating. The outline calls it the silent scenario. Let us say I publish my notice perfectly. I wait. The government does not show up to oppose. My neighbors do not show up. The courtroom is completely empty. It is just me and the judge. Do I win automatically?
You would naturally think so, right? In a boxing match, if the opponent does not show up, you win by forfeit. In civil cases, it is often the same. But in land registration, the answer is absolutely no.
Why not? Who am I fighting if the room is empty?
You are fighting the burden of proof itself. The applicant still has the burden of proof. You must show positive and absolute proof of ownership in fee simple.
Fee simple. Throwing out another heavy legal term for us.
Sorry. Fee simple basically means total, absolute, unencumbered ownership. You own the soil, you own the rights, it is yours forever. To get that declaration from the court, you have to prove your case fully, even if no one is arguing back.
So the judge is not just a passive referee waiting for a fight.
No, the judge is an active gatekeeper. He has a duty to check your evidence thoroughly. If your evidence is weak, say you just have that one tax receipt and no witnesses to your 20 years of possession, the court can and will deny your registration even if there is zero opposition.
That is a remarkably high bar. You really have to have your ducks in a perfect row.
You absolutely do. Because remember, once the judge says yes, he is creating a title that binds the whole world. He needs to be absolutely sure before he drops that gavel.
Okay, let us say I did it. I survived the publication trap. The government did not object, or I fought them and won. I proved my 20 years of OSIN. The judge bangs the gavel and says, "Granted. Are we done? Can I finally pop the champagne?"
Put the cork back in the bottle for just a moment. We're in part 6 now, the end game. First, that judgment has to become final.
The 15-day rule?
Yes.
Yes.
There is a period for appeal, which is usually 15 days. The source material really emphasizes how important it is to determine this exact period. If the government decides to appeal within that window, the war continues to the appellate courts.
Like in that Republic versus ASOC case.
Exactly. Even if the judgment seems final for the private parties, the government could still appeal if they perfected it on time. But let us say the time lapses completely. Nobody appeals. The judgment is final. Then we hit the 1-year rule.
What is the 1-year rule? Is it like a warranty period on the title?
Sort of. The decision remains under the control of the court for 1 full year after the issuance of the decree. The land is not considered finally and incontrovertibly adjudicated until this 1 year completely passes.
Oh, an entire year. What are we waiting for?
It is a safety valve, specifically designed for fraud.
Ah, so if I lied to the court or if I forged my grandfather's deeds, someone has 1 year to catch me.
Exactly. If a neighbor was out of the country and wakes up 6 months later and says, wait a minute, he forged my signature to get this land, they can petition the court to reopen the decree based on actual fraud.
But they only have that 1 year.
Generally, yes, because the Torrens system values stability above almost everything else. It cannot remain open to challenges forever. After that 1 year passes, the door slams shut hard.
And that is when we finally get the decree of registration.
Yes, this is the final step. It is not a separate proceeding. It is just the natural conclusion of the litigation. The court issues the decree.
And this decree is what has that clean slate effect we talked about.
This is truly the most beautiful and powerful part of the Torrens system. It wipes the historical slate totally clean. Once you have that decree, you hold the land free from all previous claims, all prior liens, and all encumbrances that are not explicitly noted on the certificate itself.
So if there is some bitter dispute from 1920 involving a crazy uncle and a carabao and an unpaid debt, it is just gone.
It is gone, cut off completely. The new owner holds it free from all that past baggage. You do not have to investigate the history of the land all the way back to the dawn of time anymore. You just look at the piece of paper. If it is clean, it is clean.
And just to clarify terms, because people mix this up, the decree is different from the certificate of title.
Physically, yes. The decree is the order. The certificate of title, that actual piece of paper you keep in your fireproof safe, is simply the transcript of the decree that is kept by the Register of Deeds.
Okay, that brings me to the big synthesis for today. So what of this whole deep dive? We have traced the journey from just sitting on a piece of dirt with a tax declaration all the way to a world-binding Torrens title. Why do we as a society put ourselves through this incredibly complex torture? Why the courts, the gazettes, the 20-year waits?
Because land is the absolute basis of economic wealth. If we did not have this rigorous system, if you could never be truly sure you owned the land you were standing on, nobody would ever lend you money against it. You could not get a mortgage to build a house. You could not use it as collateral to build a factory.
The economy would just freeze up.
It would paralyze the economy. The Torrens system transforms land from a physical object into a secure, tradable, liquid asset. It creates absolute certainty and trust. You do not have to trust the person selling it to you. You just trust the state's piece of paper.
Which leads me to a final provocative thought for you listening at home, something the sources hint at indirectly when they talk about the psychology of ownership. We've been talking for an hour about these paper titles binding the whole world. It is a very 20th century, highly centralized system. We rely entirely on the Register of Deeds, on physical archives, on human clerks not making mistakes.
We do rely heavily on the human element.
But look at the world we live in now. We are in the age of digital assets and changing property paradigms. We have blockchain technology where ownership is proven by a decentralized ledger that in theory cannot be hacked, burned down, or forged.
That is true.
So my question for you to mull over is this. Is the Torrens system of absolute world-binding paper titles still the ultimate security? Or is it just the best we have for now until we move to something like digital smart contracts for real estate?
That is the billion peso question, really. The Torrens system is a masterpiece of legal engineering, but it is inherently human. It is prone to lost files, to courthouse fires, to corruption and delays. Blockchain is trustless. The code proves the ownership, not a judge.
Right. It would be against the whole world by algorithm instead of by publication in a gazette nobody reads.
Exactly. I genuinely think we might get there eventually. A decentralized land registry would be faster, cheaper, and maybe fundamentally more secure against fraud. But until that day actually comes, do not rely on your crypto wallet to protect your farm. You still have to go to the regional trial court.
And you better bring your muniments.
You definitely better bring your muniments.
Thank you so much for guiding us through this incredibly dense maze today. This has been completely eye-opening.
My pleasure entirely. It is dense material, but it is quite literally the ground we walk on.
To everyone listening, go check those blue papers in your grandma's plastic envelope. And if you are sitting on land without a title, maybe it is time to start the clock on your 20 years. We will see you on the next deep dive.
Take care, everyone.
Welcome to the debate.
Good to be here.
Today, we are looking at the ground beneath our feet, quite literally. We are dissecting the mechanism of original land registration under PD 1529. That's the Property Registration Decree and, of course, the Public Land Act.
Yeah, it sounds a bit dry on paper, but this is actually one of the most, well, chemically reactive areas of law. It's where history really collides with economics. We are essentially asking a fundamental question. How does a piece of the earth, which starts as the property of the state, become yours in the eyes of the law?
And that transformation is not something to be taken lightly. The central tension we are exploring today is between state dominion on one hand and private rights on the other. My stance is quite simple. The state has a duty to safeguard the public domain. The requirements for handing over land to a private individual must be strict, unyielding, and absolutely watertight.
Right, and I take the view of equity. The law isn't a machine, it's a framework for justice. If a family has tilled the land for generations, or if a corporation buys land that has effectively become private through time, the law needs to recognize that reality. We shouldn't let procedural technicalities strangle substantive rights.
But consider the stakes here. When a court issues a decree of registration, it creates a title that is res judicata against the whole world.
Against the whole world? It sounds dramatic because it is.
Exactly. It means that once that title is issued, it quiets all other claims forever. The government can't touch it, future claimants can't touch it. Because the outcome is so final, the process has to be rigorous. This is an in rem proceeding, a suit against the thing itself. The applicant isn't just asking for a favor. They are asking the state to abdicate its sovereignty over a portion of the national patrimony.
I agree, the stakes are high, absolutely. But let's look at who these applicants usually are. Often they aren't, land-grabbing tycoons. They are people relying on what we call native title, or long-standing possession.
And that is exactly where the danger lies. My position relies on the integrity of the Torrens system. If we allow loose interpretations, if we accept mere possession as a substitute for hard proof without strict scrutiny, we undermine public trust in the registry itself. An applicant must prove ownership in fee simple. That means absolute ownership. They need muniments of title.
Muniments? There's a word you don't hear at the grocery store?
It's vital, though. Written instruments, Spanish grants, government awards. You cannot just point at a fence and say, I own this. Furthermore, we have strict constitutional limits. Individuals are generally capped at 12 hectares. And corporations? The Constitution is explicit. They are completely prohibited from acquiring alienable lands of the public domain. These are the guardrails. You don't cross them.
See, I think that perspective treats the registration process as the creation of a right. I argue it's the confirmation of an existing one. The Public Land Act allows registration for those who have been in open, continuous, exclusive, and notorious possession. We call that OCEN in the field for at least 20 years.
Under a bona fide claim of ownership, yes.
Exactly. If you have done that, the law says you are conclusively presumed to have performed all the conditions essential to a government grant. This is the key takeaway for anyone listening. Possession, if done right, converts public land into private land by operation of law. The judge's gavel just makes it official. It doesn't make it real. It was already real.
But reality in a courtroom requires evidence. And this brings us to our first major clash, really, the nature of evidence. You talk about possession as if it's a magic wand, but the Supreme Court has been very clear that possession and title are not the same thing. I want to bring up the case of Gutierrez Hermanos versus Court of Appeals.
I had a feeling you'd bring that one up. It's the classic, I was here before the Spaniards argument.
It's a classic for a reason, because it illustrates the evidentiary gap perfectly. In that case, the applicant had zero title documents, nothing. They relied entirely on native title. Their argument was essentially, we possessed and used this land even before the Spanish conquest, so we don't need a paper trail. They traced their rights to predecessors of the same category as the Cancanay tribes.
Which is a claim rooted in historical truth for many indigenous peoples. I mean, it's not just a story, it's their lineage.
Historically, perhaps, but legally, the Supreme Court shut it down. They held that if you want to claim native title in that specific context, you must show a muniment of title specifically bestowed by the Spanish crown. You cannot simply assert it. And here is where the case gets interesting regarding your possession argument. The applicant tried to use tax declarations and tax receipts as their proof.
And the court rejected them?
Emphatically. They said tax receipts are not evidence of title. At best, they are indicia of possession. Just because you pay taxes on a plot of land doesn't mean the state actually gave it to you.
Hold on. I have to push back on that dismissal. You're technically right. A tax receipt isn't a land title. But the Supreme Court has also said in multiple cases that no one in his right mind would be paying taxes for a property that is not in his actual or at least constructive possession.
Possession is not ownership. I can possess a stolen car. I don't own it.
But in land law, consistent possession is the pathway to ownership. That's the disconnect I'm seeing in your argument. A voluntary declaration of property for taxation and the consistent payment of those taxes over decades strengthens a bona fide claim. It shows the intent to assert dominion. It shows you aren't hiding. You are telling the government, here I am, this is mine, and I'm paying my share.
Strengthening a claim is distinct from proving it. The rule from Evangelista versus Tabayag, way back in 1907, still holds today. Tax receipts, unsupported by other proper proof, are not evidence of title. You cannot ask a state to sign away the public domain based on a stack of receipts. The Gutierrez-Hermanos case proves that you can have history, you can have tax receipts, but if you lack the specific grant or the specific lineage of the claim, the door stays shut.
I think Gutierrez was a failure of specific proof for a specific claim. It doesn't invalidate the principle that OKI 10, open, continuous, exclusive, notorious possession, is a valid mode of acquisition. If you have that for the requisite period, the lack of a Spanish paper shouldn't be fatal. That is what equity demands.
Equity is fine, but let's look at a situation where the letter of the law seems impenetrable, yet people like you try to find a window. Let's talk about corporate applicants.
Ah, the Acme Doctrine. This is my favorite part.
I figured. Let's look at the hard constraint first. The 1973 and 1987 constitutions are crystal clear. Private corporations are prohibited from acquiring alienable lands of the public domain, period. They can lease them up to 1,000 hectares for 25 years, but they cannot own them.
Correct. On the face of it, it's a total ban.
In T properties, the court enforced this strictly. A corporation applied for registration. They were the successor in interest of an individual, but the application covered over 56 hectares. Now remember, an individual can only register 12 hectares. The court ruled the application for the excess 44 hectares was void ab initio, dead on arrival. A corporation cannot have a right higher than its predecessor. If the land was public when they tried to acquire it, the Constitution blocks them completely.
That is a compelling argument if you assume the land is still public when the corporation buys it. But have you considered the nuance, or what you might call the magic trick, of the Acme Doctrine?
I wouldn't call it magic. I'd call it a convenient legal fiction.
It's not fiction, it's the recognition of a timeline. The Acme case establishes a vital distinction. The Constitution prohibits corporations from acquiring public land. It does not prohibit them from acquiring private land.
But in an original registration proceeding, the land is presumptively public until the decree is issued. That's the whole point of going to court in the first place.
That is the common misconception. The Acme Doctrine says the determination of the land's character happens at the time of the registration proceeding, but the change in character can happen before that. If the person the corporation bought the land from, the predecessor, had already fulfilled the 20 or 30-year requirement of OCN, the land had already become private by operation of law.
So the argument is the farmer owned it in secret because of his possession. So, when the corporation bought it, they were buying private land, thereby bypassing the constitutional ban on public land.
Perfect right or an incomplete title, the land is private. Therefore, the corporation isn't violating the Constitution. As Justice Narvasa pointed out, if the land was already private, the prohibition is irrelevant. The corporation is simply stepping into the shoes of the private owner to formalize the title.
It feels like a massive loophole. In TK Properties, the court tried to rein this in. They clarified that Acme only applies if the corporation acquires land that doesn't exceed the 12-hectare limit for individuals. You can't use a corporation to aggregate massive tracts of land by buying from multiple individuals and claiming, oh, it was all private already.
True, Acme isn't a license to build a feudal estate, but it protects the substantive right of transfer. If I, as a farmer, have earned my land through 30 years of sweat, I should be able to sell it to whomever I want, including a corporation. If you deny the corporation the right to register it, you are effectively devaluing my land because I have fewer buyers.
I see the economic argument, but I worry about the timing. If the acquisition happened during the 1973 Constitution, the ban was absolute. The court has said that if the transfer occurred then, and the land was even arguably still public, the transaction is void. I prefer the default to be protect the public domain. If there is ambiguity, the state keeps the land.
And I prefer protect the reality. If the land has been occupied and worked, the state shouldn't hoard it based on a technicality regarding the buyer's corporate status.
Speaking of technicalities that drive people crazy, let's move to jurisdiction, notice, and amendments. This is where the procedural rigor of the Torrens system really shows its teeth.
You're talking about the publication requirement?
Yes. To get jurisdiction, to get the court to even listen to you, you must publish the notice of initial hearing in the official gazette and a newspaper of general circulation. The publication in the official gazette is the holy grail. It charges the whole world with knowledge. Now imagine an applicant realizes, oops, I forgot a corner of the field, and amends the application to include more area.
It happens all the time. Surveyors make mistakes. Old maps are fuzzy.
If they add land, even a sliver, that wasn't in the original publication, the law is unforgiving. A new publication is mandatory. Without it, the court has absolutely no jurisdiction over that new area. Any decision regarding that added land is a nullity. You cannot bind the whole world to a claim they weren't notified about.
I come at this from a different angle. I agree jurisdiction is paramount, but rigorous procedure shouldn't defy common sense. We have to look at substantial compliance. Take the case of Benin versus Twayson.
Benin is an extreme outlier.
But the principle is sound. In Benin, there was an amendment to the plan. The increase in area was 27.10 square meters. The total original area was over 879 hectares. That's nearly 9 million square meters. The lower court said, you changed the area, you must republish. The Supreme Court said, don't be ridiculous.
Because the difference was microscopic.
Exactly. The court observed that a slight increase of 27 square meters did not affect the identity of the land. It didn't mislead anyone. To require a full republication process, which costs thousands of pesos and takes months, for 27 square meters on an 800-hectare estate is bureaucratic madness.
But you have to admit, there is a logic to the distinction. If an amendment excludes land, if you say, actually, I claim less, no new publication is needed. Why? Because you aren't taking more from the public pot. But adding land is an encroachment. Benin might be the exception for a tiny fraction, but the general rule is strict for a reason. Jurisdiction is not a sliding scale. You either have it or you don't.
I think Benin showed it. The court is willing to look at the substance of the notice. Did the world know what was being claimed? If the identity of the land hasn't changed, the jurisdiction should hold. It's about fairness to the applicant who shouldn't be punished for a rounding error.
We also have to consider fairness to the silent observer. This leads us to the role of opposition and the court's duty. There is a dangerous misconception that if you file for registration and no one shows up to oppose you, you win by default.
Like a boxing match where the opponent doesn't show up?
Exactly. But in land registration, that is dead wrong. Silence is not consent. In Labor versus Hondo, the Supreme Court emphasized that even without opposition, the applicant must prove ownership in fee simple to the satisfaction of the court. The judge is not a rubber stamp.
That is true. The applicant is the plaintiff. They have to rely on the strength of their own title, not the weakness or absence of the opposition.
The court has a positive duty to deny the registration if the facts don't show absolute ownership. They are the gatekeepers of the Torrens system. If the proof is weak, the gate stays closed.
However, we have to look at how aggressive the government can be. In Republic versus Asociación, the government was like a dog with a bone. Even though the private parties seemed to have settled their issues, the government appealed.
As the Solicitor General should. They represent the state.
But look at the timeline of vulnerability. The judgment isn't incontrovertible immediately. The law says the adjudication doesn't become final until 1 year after the entry of the final decree.
That's the review period. It's a crucial safety valve against fraud.
It's also a period of terror for the applicant. As long as that final decree isn't issued or that 1-year clock is ticking, the court can still set the decision aside. In Republic versus Association, the opposition came in a month after the order of general default. The court still had to listen. It creates a lingering uncertainty. You've proven your case, you've won, but the government can still walk in the back door.
The court presumed the opposition was on time because there was no evidence to the contrary. But the point stands. The door is kept ajar because once it shuts forever. We want finality, but we cannot sacrifice accuracy. If the government realizes a mistake was made or fraud was committed, they have that window to intervene.
It's a double-edged sword. We want a title that is rock solid, but getting there feels like running a gauntlet where the rules can shift beneath you.
Which brings us to the conclusion of this process, the issuance of the decree.
The finish line.
To summarize my stance, land registration is a strict state function. It is not a participation trophy. Whether it is the 12-hectare limit, the ban on corporate acquisition, or the need for specific muniments like Spanish grants, the burden of proof rests heavily on the applicant. We cannot allow the Torrens system to be diluted by substantial compliance or vague assertions. The integrity of every title in the country depends on the rigor of this process.
And I respect that rigor. But I maintain that while rules are essential, the law must acknowledge the reality of possession. The Acme Doctrine is vital. It bridges the gap between the strict constitutional ban and the economic reality of private rights acquired through time. And regarding evidence, tax declarations represent real-world commitment. The law provides a pathway for legitimate owners to formalize what is already theirs in reality, if not yet in name. We shouldn't make that path impossible to walk.
We may disagree on the path, but we agree on the destination.
We do.
The in rem nature of the outcome. Once that decree is entered, transcribed by the Register of Deeds, and the 1-year period lapses, the certificate of title binds the whole world.
It cuts off all prior claims. It wipes out liens not noted on the title. It is the ultimate clean slate.
And that is why the debate matters. Because once that slate is cleaned, there is no going back.
A sobering thought for anyone looking at a piece of land today.
That concludes our discussion on original land registration under PD 1529. Join us next time on The Debate.
What is the essence of original land registration proceedings? Discuss its nature and distinguish generally ordinary from cadastral proceedings as a mode of original registration under the Torrens system.
Original registration under PD 1529 is a proceeding brought before the regional trial court as a land registration court to determine title or ownership of land on the basis of an application or the opposition to that in an ordinary land registration proceeding or of a petition for the answer to that in a cadastral registration proceeding. In a land registration proceeding, which is in rem, the judgment of the court confirming the title and ordering its registration in one's name constitutes, when final, res judicata against the whole world. An ordinary land registration proceeding may be instituted by filing with the proper court an application by the private individual himself. On the other hand, the President may initiate a cadastral land registration proceeding by directing a cadastral survey to be undertaken and thereafter the corresponding petition be filed in court for purposes of settling and adjudicating conflicting claims over such land.
What requirements and limitations apply in cases involving judicial confirmation of title over alienable and disposable lands of the public domain?
An application for original registration of title to land may involve an area not exceeding 12 hectares. alienable and disposable lands of the public domain, the application may be filed by those who, by themselves or through their predecessors in interest, have been in open, continuous, exclusive, and notorious possession and occupation of alienable and disposable lands of the public domain, not covered by existing certificates of title or patents under a bona fide claim of ownership for at least 20 years, immediately preceding the filing of the application for confirmation of title, except when prevented by war or force majeure. They shall be conclusively presumed to have performed all the conditions essential to a government grant and shall be entitled to a certificate of title under the law.
What are muniments of title?
Muniments of title are instruments or written evidence which the applicant holds or possesses to enable him to substantiate and prove title to his estate. In Gutierrez Hermanos versus Court of Appeals, the Supreme Court observed that no title or document of ownership was presented by the applicant. The applicant admitted in its brief that it had no titles except what it called native titles consisting of tax declarations and tax receipts. Gutierrez Hermanos comes up with a rather ingenious claim that there was no necessity for the applicant to submit any muniments of title because even before the Spaniards arrived, the said lands were possessed, owned, and used by the applicant and its predecessors in interest as natives. The applicant traces its rights to the predecessors of the same category as the Igorots of the Kankani tribe in Benguet. The Supreme Court held that the applicant must show a muniment of title specifically bestowed by the Spanish crown if its theory of the case is to succeed. Tax declarations and tax receipts are not muniments of title. The rule enunciated in the 1907 case in Evangelista versus Tabayoyong that tax receipts are not evidence of title to land unsupported by other proper proof is as true today as it was true then.
What is the probative value of tax declarations or tax receipts as evidence of ownership of lands?
Or realty tax payments of property are not conclusive evidence of ownership. At most, they serve as a good indicium of possession in the concept of an owner. Such an act strengthens one's bona fide claim of acquisition of ownership. In a recent case, the Supreme Court stated that although tax declarations and realty tax payments of property are not conclusive evidence of ownership, they are nonetheless good indicia of the possession in the concept of owner, for no one in his right mind would be paying taxes for a property that is not in his actual or at least constructive possession. Thus, a voluntary declaration of the subject property for taxation purposes and payment of such tax would strengthen one's bona fide claim of ownership over the subject property.
Who may acquire title to alienable and disposable lands of the public domain?
Only natural-born Filipino citizens may acquire not more than 12 hectares by purchase, homestead, or grant, or lease not more than 500 hectares. Private corporations, on the other hand, may lease not more than 1,000 hectares for 25 years, renewable for another 25 years.
When may private corporations be applicants in original land registration proceedings?
In one case, the Supreme Court ruled that if it is accepted, as it must be, that the land was already private to which the infieles had legally sufficient and transferable title on October 29, 1962, when ACME, a corporation, acquired it from the said owners, it must also be considered that ACME had a perfect right to make such acquisition, there being nothing in the 1935 Constitution then in force, or for that matter, in the 1973 Constitution, which came into effect later, prohibiting corporations from acquiring and owning private lands. The Supreme Court went further on to say that even on the proposition that the land remained technically public land, despite immemorial possession of the infieles and their ancestors, until title in their favor was actually confirmed in appropriate proceedings under the Public Land Act, their can be no serious question of ACME's right to acquire the land at the time it did. There also being nothing in the 1935 Constitution that might be construed to prohibit corporations from purchasing or acquiring interests in public land to which the vendor had already acquired the type of so-called incomplete or imperfect title. Determinative of this issue is the character of the parcels of land, whether they were still public or already private when the registration proceedings were commenced. If they are already private lands, the constitutional prohibition against acquisitions by a private corporation would not apply. Justice Narbasa thus states in the ACME case that the question turns upon a determination of the character of the lands at the time of the institution of the registration proceedings in 1981. If they were then still part of the public domain, it must be answered in the negative. If, on the other hand, they were then already private lands, the constitutional prohibition against their acquisition by private corporations or associations obviously does not apply.
Where it is appropriate for private corporations to be applicants in original land registration proceedings, what limitation applies, if any?
In the TAN Properties case, the corporation, as successor in interest of an individual owner of the land, was held not entitled to apply for registration of land in excess of 12 hectares. Since it applied for 56.4007 hectares, the application for the excess area of 44.4007 hectares is contrary to law and thus void ab initio. In applying for land registration, a private corporation cannot have any right higher than its predecessor in interest from whom it derived its right. This assumes, of course, that the corporation acquired the land not exceeding 12 hectares when the land had already become private land by operation of law. In contrast, where the applicant acquired the land subject of the application for registration through a deed of assignment executed in 1976, when it was already prohibited to acquire any kind of alienable and disposable land of the public domain under the 1973 Constitution, it cannot be the applicant. The Supreme Court explained that when the 1973 Constitution took effect, it limited the alienation of lands of the public domain to individuals who were citizens of the Philippines. Private corporations, even if wholly owned by Filipino citizens, were prohibited from acquiring alienable lands of the public domain. At present, the 1987 Constitution continues the prohibition against private corporations from acquiring any kind of alienable land of the public domain.
Discuss the jurisdictional requirements regarding the publication and service of notice of initial hearing in ordinary land registration proceedings.
The law requires notice of initial hearing to be published once in the official gazette and once in a newspaper of general circulation in the Philippines, provided, however, that the publication in the official gazette shall be sufficient to confer jurisdiction upon the court. The purpose of the publication is to confer jurisdiction over the land applied for upon the court and to charge the whole world with knowledge of the application relative to the land involved and invite them to take part in the case and assert and prove their rights over the subject land, if any. Section 23 of PD 1529 requires mailing within 7 days after publication of the notice of initial hearing in the official gazette, of notice to persons named in the notice, the Secretary of Public Highways, Provincial Governor, and Mayor, if the applicant requests to have the line of a public way or road determined, the Secretary of Agrarian Reform, the Solicitor General, Director of Lands, Director of Fisheries, and Director of Mines, if the land borders on a river, a navigable stream or shore, or an arm of the sea where a river or harbor line is established, and other persons as the court may deem proper. Posting is also required in conspicuous places on the subject land and on bulletin boards of municipal buildings at least 14 days before the initial hearing.
What jurisdictional requirements must be complied with in case of amendments to the application in an ordinary land registration case?
If the amendment consists in the inclusion in the application for registration of an area or parcel of land not previously included in the original application as published, a new publication of the amended application must be made. The purpose of the new publication is to give notice to all persons concerned regarding the amended application. Without a new publication, the registration court cannot acquire jurisdiction over the area or parcel of land that is added to the area covered by the original application, and the decision of the land registration court would be a nullity insofar as the decision concerns the newly included area. But if the amendment consists in the exclusion of a portion of the area covered by the original application and the original plan as previously published, a new publication is not necessary. In the latter case, the jurisdiction of the court is not affected by the failure of a new publication. In Benin versus Tuason, the Supreme Court observed that a very slight increase of 27.10 square meters would not justify the conclusion of the lower court that the amended plan included additional lands which were not originally included in the original parcel of land applied for as published in the official gazette. It is undisputed that the original parcel of land applied for had an area of more than 8,798,600 square meters or 879.86 hectares. So the Supreme Court believed that this difference of 27.10 square meters between the computation of the area when the original plan was made and the computation of the area when the amended plan was prepared cannot be considered substantial, as would affect the identity of the original parcel of land applied for. It is settled in this jurisdiction that only in cases where the original survey plan is amended during the registration proceedings by the addition of lands not previously included in the original plan should publication be made in order to confer jurisdiction on the court to order the registration of the area that was added after the publication of the original plan.
When should the opposition in an ordinary land registration proceeding be filed?
The opposition or answer must be filed on or before the date of the initial hearing. In Republic versus Asociación Benévola de Cebu, the Supreme Court noted that the records disclose, and this is admitted by a respondent judge in his order, that there was a written opposition from the government through the Solicitor General and the Director of Lands. Although this was received by the trial court 1 month after the order of general default was entered, there was no evidence showing when the opposition by the government was filed. In the absence of such evidence, it is presumed, according to the Supreme Court, that the opposition was filed on time and was not covered by the order of general default. It is clear that the government has challenged the application for registration since the very start of the proceedings. It further reasoned that assuming in gratia argumenti that the opposition was not filed on time, nevertheless an oppositor is still allowed to present evidence to prove ownership of the disputed land despite the declaration of general default against him, provided that a decision has not been rendered or that a decree of registration has not been issued in this case.
What may serve as basis for the filing of an opposition in an ordinary land registration case?
In Leyva versus Hando, the Supreme Court emphasized that an opposition must be based on a right of dominion or some other real right, independent of and not at all subordinate to the rights of the government.
What course of action is available to the court where only a portion of the area of the land applied for registration is contested?
Only a portion of the land applied for is contested, but such portion is not properly delimited. The court may require the submission of a subdivision plan approved by the Director of Lands.
Would the absence of opposition to the application in ordinary registration proceedings necessarily entitle the applicant to a judgment in his favor?
It is an established rule that an applicant for registration is not necessarily entitled to have the land registered in his name simply because no one appears to oppose his title and to oppose the registration of the land. He must show, even in the absence of opposition, to the satisfaction of the court that he is the absolute owner in fee simple. Courts are not justified in registering property under the Torrens system simply because there is no opposition offered. Courts may, even in the absence of any opposition, deny registration of the land under the Torrens system if the facts presented do not show that the petitioner is the owner in fee simple of the land which he seeks to register. According to the case of Gutierrez Hermanos versus Court of Appeals, the denial of a petition for registration simply indicates that the applicant does not furnish that kind of proof showing an absolute title in fee simple, which is required under the Torrens system. It is the duty of the courts, even in the absence of any opposition, to require the applicant to show by a preponderance of evidence and by positive and absolute proof, so far as it is possible, that he is the owner in fee simple of the land which he is attempting to have registered.
When does a judgment in a land registration case attain finality?
Judgments or orders become final and executory by operation of law and not by judicial declaration. The finality of a judgment becomes a fact upon the lapse of the reglementary period of appeal if no appeal is perfected or no motion for reconsideration or new trial is filed. Hence, the determination of the period of filing an appeal is crucial. Following this principle, the Supreme Court in Republic versus Asociación Benévola de Cebu had ruled that if ever there was an entry of judgment in that case, dated September 14, 1984, this had the effect of finally disposing and putting an end to the controversy with regard only to the private respondents therein, as among themselves and not insofar as the government's interest on the land is concerned. As to the government, the judgments have yet to attain finality because its appeal was perfected on time before the lapse of the period within which to appeal. The same case of Republic versus Asociación Benévola de Cebu made note of the fact that the adjudication of land in a registration or cadastral case does not become final and incontrovertible until the expiration of 1 year after the entry of the final decree. As long as the final decree is not issued and the 1 year within which it may be revised has not elapsed, the decision remains under the control and sound discretion of the court rendering the decree, which court, after hearing, may set aside the decision or decree or adjudicate the land to another party.
When is it proper to entertain an appeal in a land registration case?
In case of appeal in land registration cases, the appellant must show that his rights or interests have been prejudiced by the decision appealed from and that he challenged the application for registration or participated in the proceedings before his appeal may be properly entertained.
What is the legal significance of the issuance of the decree of registration in the entire context of a land registration case?
Jurisdiction over land registration cases, as in ordinary actions, is acquired upon the filing in court of the application for registration and is retained up to the end of the litigation. The issuance of a decree of registration is but a step in the entire land registration process, and as such does not constitute a separate proceeding. After the registration is completed and finalized in the regular course, the rights of all adverse claimants are foreclosed by the decree of registration. The government itself assumes the burden of giving notice to all parties. In National Grains Authority versus Intermediate Appellate Court, Justice Paras observed that under Section 44 of PD 1529, every registered owner receiving a certificate of title in pursuance of a decree of registration and every subsequent purchaser of registered land taking a certificate of title for value and in good faith shall hold the same free from all encumbrances except those noted on the certificate of title and any of the encumbrances which may be subsisting and enumerated in the law. Under said provision, claims and liens of whatever character, except those mentioned by law as existing against the land prior to the issuance of the certificate of title, are cut off by such certificate if not noted thereon, and the certificate so issued binds the whole world, including the government. As soon as the decree of title has been registered in the office of the Register of Deeds, the property included in the said decree shall become registered land. The certificate shall take effect upon the date of the transcription of the decree. The certificate of title is the transcript of the decree of registration made by the Register of Deeds in the registry. The decree of registration shall contain a description of the land as finally determined by the court.